Thank you, ladies and gentlemen. Please take your seats. I hope you had a little coffee, and we can begin our event again. That's good. I want to thank you again for joining us in this event. The one comment that I think I have from the previous panel is the concept of corruption. I was in Washington, D.C. Last week with some academics thinking about corruption, and it is indeed a very difficult concept to pin down. It can involve just about any behavior, and so it's a concept that I think it's best broken down into types and then behaviors and crimes. And Mexico, I think, will continue to struggle with this issue of corruption, which of course affects public safety and security. And to deal with some of these important issues that Mexico is facing today, we have a truly stellar panel, which of course follows our stellar keynote this morning, Justice Medina Mora. The panel is composed of four of these citizens that I mentioned in my introduction, and that give cause for optimism and the idea that there are people in Mexico that are working very hard on this issue. And our four panelists, I think, are great examples of people who are working very hard for the rule of law in Mexico, however that may be translated, the rule of law, Estado de Derecho, Imperio de la Ley, or Estado de Cosas, which I just, new term that I just learned. So let me introduce, to my left, we got Catalina Perez Correa. She's a professor of law at CIDE, University in Mexico. Catalina Perez Correa is a professor and researcher at CIDE. She received her LLM and JSD from Stanford University Law School, and she has been a visiting fellow at the Shell Center for International Human Rights at Yale University, and of course my own alma mater, Georgetown University. Her research focuses on the study of legal procedures and practices, particularly the functioning of the criminal justice system in Mexico. She has conducted surveys on Mexican prisons to study prison conditions, due process rights, and the cost of imprisonment to inmates and their families. She recently conducted a survey on prison personnel to study the working conditions in prisons. She also studies gender in the criminal justice system and drug policy in Latin America. The rest of her bio, I think you can read online. It's quite extensive. Then we got Carlos Bravo Regidor, whom I follow on Twitter. Quite controversial, I think. I read whatever he posts, I read it faithfully because I think it's quite interesting. It's one of those voices in Mexico that is really a counterweight to what's going on in many ways. Carlos Bravo Regidor is an associate professor and coordinator of journalism, the journalism program at CIDE as well, a public center that specializes on social studies, and it's in Mexico City. He got a BA in International Relations at Colmex, el Colegio de Mexico, and an MBA and a PhD in History at the University of Chicago. His areas of academic specialization are history and contemporary politics in Mexico, in the United States, the bilateral relationship in both countries, and democracy, media, and journalism. As a political analyst, he has written for the New York Times in Spanish, Dissent magazine, Letras Libres, and of course Reforma, a paper in Mexico City, one of the major papers in Mexico City. He's a regular collaborator in the radio show Atando Cabos, Tying Loose Ends, I guess that would be the translation, with Denise Merker and Así las Cosas with Gabriela Warkentin and Javier Risco. In television, he's also a regular collaborator of Leo Zuckerman's La Hora de Opinar and Ricardo Rafael's Calle Once. And then we have Eduardo. Eduardo Bojorquez next. Eduardo has been here before in an event about 3 years ago, because in the Mexico Center we've looked at this issue many different times. Eduardo Bojorquez is the director of Transparencia Mexicana. Over 20 years of experience in transparency, anti-corruption, and public sector reform. Former board member of EITI, responsible for crafting the 3 de 3 initiative, which was a public disclosure of conflicts of interest initiative in Mexico. Key stakeholder in the design of the national anti-corruption system, civil society liaison for Congress, excuse me, with Congress for the 2016 National Anti-Corruption System Secondary Law or Implementation Law process. He was awarded the Open Government Partnership Prize for the creation of the civic participation model for daycare units, and he pioneered open contracting both in Mexico and at the international level. He's a board member of Mexico's Agency for International Cooperation, AMEXID, and the National Council of Open Data, as well as the National Protected Natural Areas, Commission. Finally, we have, David Garcia Sarubi. He's a law clerk at the Supreme Court Justice in Mexico. David Garcia Sarubi earned his law degree at the Instituto Tecnológico Autónomo de México, ITAM, and his graduate degree, LLM, from NYU, where he received the Dean's Graduate Award. He holds a master's degree in human rights from ITAM and a graduate degree in constitutional law from the National Autonomous University in Mexico City. He has been a clerk to Justice Gutierrez Ortiz Mena at the Supreme Court since 2013, and he's currently a professor of law at ITAM, where he teaches constitutional law. He has published articles on these matters and has specialized on issues relating to federalism, the division of power, regulatory state, and judicial review. And with that, I assure you it's a stellar panel, quite well prepared to discuss this topic today. We're going to give them about 12 minutes each or so to make their preliminary remarks, and then we'll have an open conversation with them. And I think, Catalina, you're going first.
Okay.
You may do it from there, or may do it from here.
That's fine. Good morning, everybody, and thank you for the invitation to be here, especially for Rodrigo and Tony for the invitation. So my talk, or these initial comments, are going to focus on the militarization of security in Mexico and the legal, the laws that have been enacted to procure that. So this really goes further than 2006, but I will begin in 2006, when Felipe Calderón announced the first joint operation to fight organized crime. The Ministry of National Defense, SEDENA for its acronym in Spanish, deployed more than 4,000 soldiers for this operation. On the 4th of January of 2007, and remember, Felipe Calderón initiated his administration on the 1st of December of 2006. On the 4th of January of 2007, the federal government sent 3,500 soldiers to Tijuana, a city which is less than an hour away from San Diego in California. On the 21st of January 2007, Calderón announced further operations in Tijuana and new ones in Guerrero, Chihuahua, Durango, and Sinaloa. The operation in Guerrero initially included the participation of 6,400 soldiers, and the Sierra Madre joint operation, which was in Chihuahua, Durango, and Sinaloa, included more than 9,000 soldiers. Throughout that administration, the militarized model of security was extended to most parts of the country. Today, 13 years after the first operation, most of Mexico has permanent military operations. In 2012, the last year of President Calderón's administration, SEDENA reported that they had 75 permanent operation bases across the country. By 2016, there were 142. In 2012, These bases could be found in 19 of the 32 states in Mexico. By 2016, 24 of the 32 states had military bases which were permanent. This represents 75% of Mexico's territory. Currently, over 50,000 soldiers are deployed across the country every day to carry out tasks that are not related to national defense. Sedena is today in charge of distributing petrol across the country, constructing, and the new López Obrador administration has announced will be administrating the new airport of Santa Lucia. They have schools across the country to form young boys and girls, programs to fight addiction, reforestation programs, and etc. Our Constitution has two clear bans on using the military. First, Article 21 states that public security tasks should be carried out by civil institutions. Second, it states that during times of peace, the military can only carry out activities strictly related with military discipline. And as Justice Medina Mora has pointed out, the way that they have been used and deployed is with a military approach of security, using military rules of engagement. So they're doing all of these functions across the country with military rules of engagement and under military discipline rules of law. The first attempt to regulate military participation after 2006 was to include a chapter on internal security in the national security law. And for several reasons that I won't go into today, this didn't go forward. The second attempt was made by the end of the Peña Nieto administration, which was the enactment of the internal security law. And I won't go into detail of that because I know David is going to talk about that. This law, I will just say, was approved in 2017 amongst huge protests. The the United Nations High Commissioner, several different rapporteurs, including extrajudicial killing, arbitrary detentions, the Inter-American Commission, the National Human Rights Commission, asked the government not to approve this law and warned against the dangers of approving such legislations. And here I will digress with Justice Medina Mora in his comments about the militarized model as a useful or even an innocuous tool. The data that we have collected from academia in Mexico shows different things. First, the growing use of lethal force for different armed forces institutions in the country. And I'll just give you a few statistics on that. We measured from CIDE and the National University Institutes, the Legal Institute, different indicators to measure the use of lethal force by armed and federal forces. One of these indicators was the lethality index, which measures how many people are wounded and killed every time there's an engagement with civil oppositions. In 2007, the lethality index for the Army was 1.6. That means there was 1.6 people dead for every person that was wounded. By 2012, it was 14.7. This means that 14.7 people were killed for every person that was wounded. And just to put these numbers into context, the Las Vegas shooting, which you probably remember, in 2007, where a person was on a rooftop shooting at a crowd in a concert, left 28 people dead and wounded 851. The Orlando shooting in a bar, where somebody came into a closed bar and started shooting against the people that were inside the bar, left 49 people dead and 53 people wounded. The International Red Cross has made different studies, and they show that in a war context, there's usually 4 people that are wounded for every person that is dead. And this is just a comparison to the lethality index that our Army has, which is 14 people dead for every person wounded. So it's an inverted index. So basically, this data suggests the existence of systematic extrajudicial killings by our armed forces, especially in certain places like Tamaulipas or Zacatecas. The longer the armed forces remain on the streets, the data shows, the more lethal that they become. We also have data that shows that the more incidents, the longer that they remain on the streets, the more incidents of the use of general force in general, including illegal use of force like torture. Second, the longer the armed forces remain on the street, the better we have also data that shows this, the better equipped organized criminals become. So what we have now is a race of armament between organized criminals and the Mexican state. And third, the longer that the armed forces have remained on the street, the conditions of local police have worsened. We today have worse police than before and less money to create functioning police, whether they're municipal or local at the state level or even federal, because we are spending it all on better equipping the military. Of course, I agree with Justice Medina that the state must be present and that's one of the main components of a rule of law. But there is a problem with making that present that of the armed forces. Streets, the existence of streets, electricity, schools, healthcare. The state is absent in all of these areas in many parts of Mexico, and that absence cannot be compensated simply by the presence of armed forces. The idea of an army, a police force that occupies a territory doesn't work in the long run. And it doesn't work because it works for a brief time, but once that occupational army retreats, there's nothing left, and nothing was constructed during the presence. So the studies show that for security to be sustainable, it has to be produced from communities. It can't be imposed from the national, the federal level to be sustainable. In 2018, 10 out of 11 justices declared unconstitutional the national security law. Well, it was actually 9 because one of the justices didn't vote in the end for another reason, but it was 10 out of 11 justices thought that the law was unconstitutional. By then, López Obrador had already won, but was not yet president. During his campaign, he had promised repeatedly to demilitarize the country and to strengthen police forces, acknowledging the problem that militarization posed for the possibility of achieving peace in Mexico. Yet once he won, his discourse changed dramatically. He stated that the military would remain on the streets, and since the Supreme Court had declared the internal security law unconstitutional, a change in the constitutional was necessary. So the first proposal for the National Guard was a completely military institution, giving Sedena, the Ministry of Defense, full control of the National Guard. And this didn't go through in the Senate. The second proposal, which was the one that was approved to create the National Guard, was very different, putting the Guard under clear civil command. Yet there were at least two transitory articles that give the armed forces possibility to remain on the streets. First is a transitory article that allows 5 years where the president can use the armed forces for public security tasks as long as, and it establishes several principles, it is extraordinary, regulated, fiscalized, subordinate, and complementary to the use of civil institutions. And the second is another transitory article that established that the military and the Navy police, along with members of the federal police, will participate in the initial confirmation of the National Guard. So the questions now are, how strong will civil control of the National Guard be? And so far, the signals of López Obrador are not promising. This week, and this is only this week, the López Obrador administration announced that a military inactive will command the National Guard, meaning that he or she will be subordinated to the Secretary of Defense, making it basically a military institution. Also, the Secretary of Defense was the one that presented the uniforms for the National Guard. And lastly, today, it's in the newspapers in Mexico, it says that they will begin recruiting of the National Guard. Sedena will do the recruiting for new members of the National Guard, even though the secondary laws have not yet been approved. So the signals are not promising. The only signal that we have had that there will be a strict civil control over the National Guard and that it will not have military rules of engagement and military laws in operation is López Obrador saying, I am a civil and I will be in command of the National Guard, so everything will be under civil control. And so, of course, this is very worrisome news in terms of having a civil institution that will not only work as an occupational force in the Mexican territory, but that will someday produce sustainable security in different parts of Mexico. And I'll leave my remarks at that so that my colleague panelists have a chance to talk. Thank you.
Thank you, Catalina. Carlos.
Well, thank you very much to all of you for being here. Thank you to the Baker Institute for the invitation. Tony Payan, Rodrigo Montes de Oca, thank you very much. It's an honor to be here at the Baker Institute and an honor to be sitting here with my friends and colleagues. I will try to present to you a perspective, a double perspective on criminal policy and violence in Mexico. On the one hand, and this is a perspective from where I stand, I mean, what anthropologists call my place of enunciation. I run a journalism program at a small public research and research and teaching center in Mexico City. And so I want to talk about security policy in Mexico from two fronts. Number one, from an academic front, and another one from a more journalistic front. From the academic front, what I mean is there is a lot of accumulated knowledge that we have gathered about violence in Mexico for at least the last 12 years. There is a multitude of institutions, experts, projects that have devoted their resources and their talents to try to understand and explain the dynamics of criminal violence in Mexico during at least the last decade. There has been a lot of research conducted, a lot of data collected, a lot of indexes built, and of policy recommendations and evaluations delivered. I say this to point out that the new government, the López Obrador administration, that took office about 16 or 17 weeks ago, just 16 or 17 weeks ago, have a major pool of accumulated knowledge from where to draw evidence, evaluations, lessons, in order to design and implement its new security policy. And yet, there is very little, if any, of it in the new government's security policy. It's not the very definition, no, let me put it this way. The new government's policy is the very definition of a not evidence-based policy. There is, to start with, a certain continuity of a merely punitive focus on force and command, a lack of substantive considerations about the social roots of criminal violence, which is said to be supplemented by the very ambitious social policy that the government has developed. But that social policy consists mainly in throwing money at poor people. There is not a single document or a single discourse, a single interview in which the president or cabinet members have explained the step-by-step logic according to which their social policy will end up producing results regarding violence and crime. The problem is not necessarily or not only poverty, but social mobility and impunity. And regarding those issues and their relationship with violence levels, there is really nothing to be found in the new administration's policy. We also know, and Catalina was talking about this, so I'm not going to dwell a lot into it. We also know that the use of armed forces to carry out tasks of public security is very popular. It has always been very popular. It boils really well. But we also know that it does not produce good results. It does not lower violence levels. It does not lower homicides. It actually increases them. Nobody really expected the new administration to bring the armed forces back to their headquarters on day one. That's for sure. It takes, and it will take, a plan, and it will be gradual. But nobody expected either for the new government to reform the Constitution in order to institutionalize the role of the armed forces in public security tasks. We have, in fact, legalized an emergency measure. Militarization of public security in Mexico is the new normal. And the new government has no plan to strengthen police forces. It has no plan in terms of prevention, and it has renounced to even pretend to have one. The new government has sold the idea that people cannot be left on their own to face criminal violence, and so that we need the armed forces there because police just doesn't work and it will never work. But in doing this, what the new policy has done and what the new legislation is doing, I think, is actually leaving the Mexican people on their own to face the excesses and abuses of the armed forces. Human rights violations, forced disappearances, extrajudicial killings. Nothing in our experience and in our accumulated knowledge tells us or predicts that they will stop with these measures. They actually, indicate that all of these abuses will continue. And I say this, carefully, not trying to compare or to create a false equivalence between the armed forces and criminal organizations. What I'm saying is too much power without checks tends to become arbitrary. That we know. That has happened in Mexico, and it will still happen with this policy and these reforms. The new government's policy is also, one of the most frustrating things to trying to understand it is the lack of an actual diagnosis. There hasn't been an effort, or at least, a publicly known effort, to try to place Mexican security policy in a comparative perspective. The new security policy in a comparative perspective, to try to base it or to make explicit the successful or international or regional experiences it is based on. One of the key problems of this policy, apart from the ones that my colleague Catalina Perez Correa was already talking about, is the fact that it seems to repeat something that we know doesn't work, and it's the philosophy of one size fits all. We know, when we talk about violence in Mexico and crime in general terms, but what we know at the local level is that there are actually many violence and many different sort of criminal organizations. Violence dynamics in Tijuana are different from violence dynamics in Chilpancingo or in Tepito or in Colima. And this points to the need of having local policies and policies that have social roots at the ground level. And the new government's policy in general turns to have a very different perspective on this. And we know that this also doesn't work. The most successful experiences we've had in Mexico are the ones that are built bottom up with social roots at the local level, and not the ones that end up feeling as if they were imposed from the outside, with federal forces that have no actual roots in the communities they end up acting in. We also know that a key component of a successful security policy is its relationship with justice institutions. And what we are seeing regarding the new government's policy is much more a logic of war, of rule, let me put it this way, rule by force, than an actual logic of rights, of rule of law. And I'm not going to dwell into this much more, but in general, my sense is that this government's policy is failed from its origins because it's based on this sort of politics of unlearning from previous experience, from accumulated knowledge, from all the evidence we've gathered. Now I want to talk a little bit about what I call like a journalistic perspective on this, or more to the point, a perspective from journalism. In Mexico in general, the working conditions for people in the press and for reporters are very poor, particularly outside of big cities, Mexico City, Guadalajara, and Monterrey. Reporters barely have benefits. Sometimes they don't even have contracts, no social security, no actual protection of their rights. On top of that, we have a crisis of media in Mexico, not only because there's a global crisis in terms of the business model of media, not being able to finance the business, but also because the new government, and I actually agree with this measure, has decided to cut public funding for media, to cut the budget for official publicity in half. So this has created really a shock in the media industry. A lot of layoffs have been made, a lot of cuts. And this ends up becoming a cost, a very heavy load put over the shoulders of reporters. They have very low salaries and insane workloads. On top of this, we have violence and a context of impunity in which aggressions against journalists have been increasing significantly with the years. With the Calderón administration, 37 journalists were killed. During the Peña administration, 66 journalists were killed. In the 7 weeks that López Obrador has been president, already 6 journalists have been killed. And I'm just talking about actual homicides, but there are a lot of other sorts of aggressions that are happening and are actually accumulating. Article 19 has documented that most of these aggressions and most of these homicides tend to come from what we call the gray zone. This place where you can't really tell where criminal organizations end and where authorities begin. There's a lot of collusion, particularly at local level. This is not something that tends to happen in the big cities. This happens more in the province in Mexico City. And these killings have a tremendous effect, not only, of course, obviously, in the freedom of speech of journalists, of the places they worked at, but it also has a tremendous effect in terms of becoming an obstacle for the Mexican people's right to know. This is something that I think we've failed in terms of explaining that violence against journalists is a problem not only for journalists and not only for the media, but actually for the Mexican public. We have seen the development in the U.S. There's a lot of talk about news deserts, but in Mexico, what we've seen is also the growth of silence zones, of places where things that are happening in terms of crime, are not talked about, are not published. There's just silence, and the quality of democracy suffers when journalists can't do their job, when they cannot inform the public of what's going on. And on top of all of this, we have something that is not only Mexican, I think this is a worldwide phenomenon, of a new sort of context of hostility against the press. The rise of these new sort of populist or authoritarian strongmen has meant that there's this political push to discredit the press. And here I would like to introduce a distinction that I think is very important. These sort of figures love the media, but they hate journalism. And they love the media because media means entertainment, media means scandal. Media provides visibility to power. But they hate journalism and they attack journalism. When journalism means information, it means accountability, it means this old-time formula, telling truth to power. In Mexico, another thing that has happened lately, particularly during the Peña administration, was the fact that in many ways, journalism started becoming a sort of substitute to justice institutions in terms of investigating corruption. What we know about corruption in Mexico at the public level comes a lot more from journalistic investigations than from actual judicial investigations. And this puts journalists at an additional risk level. So the combination of all of these factors creates a tremendous social cost in terms of undermining freedom of expression and the freedom of the press. When we need it most to see, to document, to know what is going on, the press is being weakened. So to sum up, we have that politics of unlearning that I was talking about at the beginning, which means there is a very slim chance for the new policy of the López Obrador administration to provide actual results in terms of reducing violence levels, and the politics of silence regarding the press, meaning that the public is not and will not be able to fully know what is going on and to make authorities accountable. In both counts, democracy suffers. Rights are not upheld and exercised, they are weakened. Thank you very much.
Thank you, Carlos. I think we'll hear from Eduardo next. Eduardo.
Good morning, everyone. Thank you very much for the kind invitation, Tony. Because I'm not an academic thinker like Carlos and Catalina, and I'm not also a public servant like David, let me bring back a very old story of a movie by Sergio Leone, The Good, the Bad, and the Ugly, and let me try to summarize something very complex, as you were mentioning, Justice, which is anti-corruption and new institutional design in Mexico for fighting corruption or controlling it. The good part of the story has been already mentioned. There is a growing demand in public opinion, in civil society, in the business sector to control corruption in the country. This is something completely new. The business sector adapted and was very pragmatic about the presence of corruption in Mexico for decades. In 2015, for the first time, the head of a very important business council in the country, the Consejo Coordinador Empresarial, openly stated that half of the problem of corruption in Mexico was the responsibility of the private sector. This was something that shocked even some members of the council, no? This public acknowledgement of the core responsibility of the private sector in the operation of corruption in Mexico. So there is a growing demand, and that's very good news. If you review every single poll in 2018 around the election, but not only around the election, even the public statistics from the National Statistics Office, the two main issues that are covered by this panel and this conference, security and corruption, were considered by Mexican population the top priorities for any government, regardless of its political or partisan origin. These are problems 1 and 2 for every single household and family in Mexico: corruption and security. So those are the good news. Civil society and the private sector got organized in 2014 and 15, started to build a broad coalition of a common interest. This coalition could be labeled as an anti-corruption coalition, and I want to be very, very careful not to mention the idea of a rule of law or pro-rule of law coalition, because it wasn't. No, rule of law was very important for a group mostly related with the private sector and some academic thinkers. But for instance, human rights organizations, they didn't buy the concept. That's the complexity of the concept. They were basically saying this is a pro-human rights approach, and what we want to do is secure human rights and corruption is in the middle between the provision of those public goods like those considered by human rights. So this broad coalition, instead of going to the streets like in Brazil, no, we didn't demonstrate. We didn't want the government to go away or political parties to disappear. This wasn't an Arab Spring approach. No? It wasn't an approach that could be linked to Ukraine or Hungary or Guatemala in terms of saying, let's demonstrate publicly against corruption. So instead of going to the Zócalo, we went to the Senate. And that was a very shocking idea for Mexican society. No? Instead of demonstrating publicly against corruption, we wanted to create a new institutional framework. Just to give you one very simple indicator, I'm not saying that each one of these articles is beautifully crafted. It was discussed and negotiated by Congress, and you know, in the very old tradition, what Congress produces is not necessarily something fantastic. But just to give you an idea, this coalition managed to reform the Constitution, to approve 7 laws, from a new special prosecutor for corruption to a national anti-corruption system, publicly discussed in the Mexican version of C-SPAN, which is a channel of Congress. No? There were public discussions between senators and experts and citizens, not hearings. I'm not talking about hearings. I'm talking about open parliaments, formal discussion of each one of the 442 articles that were reviewed and approved, and a new system was created. So, you know, everything seemed to be going in the right direction. Obviously, the system is not perfect. No, the institutional design has many, many challenges. Implementation is always a problem, but we were going towards the right direction. Having a broad coalition for reforming anti-corruption, securing implementation, bringing citizens to the discussion. That's the good part of the story. Let me go to the bad part of the Sergio Leone movie. The political class noticed that this was a major systemic reform. And when they discover how deep into the roots of that model of organization we were talking a few minutes ago, the organization of government and the state, and when they notice and realize that they were under a very severe scrutiny from civil society and media and public opinion. When you mentioned Tony 3 de 3, we are so acquainted with the brand that we forget the essence of the issue. And it's particularly sensitive in the US. I'm going to mention what 3 de 3 was just one article out of 442 articles. And this article made mandatory the disclosure for every public servant of assets, a public declaration of assets, of interests, not conflict of interest, be aware of that, no? Disclosing the interest of the public servant. And third, we were demanding a public recognition of taxes. In some cases, the public disclosure of taxes, you know how sensitive the issue is in DC, but it was relevant in terms of fiscal justice to understand that those that were serving us as public servants were also in the position of using resources because they were contributing to the national wealth. Just a minor footnote. When we were discussing this with senators and Congress people, federal Congress people, we were discussing assets, interests, and taxes. They didn't have a problem with assets. No? There were a group of Congress people in Mexico that came to me and said, well, I have no problem in telling you how much I have and own. No, it's not a problem. I have 27 million pesos. I have 40 million pesos. It's not a problem. The problem is that I don't have a fiscal identity number, so I haven't paid taxes ever in my life. The issue was so big that the tax authority, the Mexican version of the IRS, had to start a special program with Congress to make these people accountable in terms of paying taxes. They didn't have an ID number, and they had no problem in telling me, no, 27 million pesos, a Grumman, I have a Cessna, no, I don't have a problem with my Bentley, but I haven't paid taxes ever. And I consider the remuneration that I'm receiving from Congress not a salary, but a kind of an incentive, no? So this is how deep into the political behavior of the country this reform was heading, and you can't imagine the backlash and the resistance for this. No? Implementation became really problematic. There were many signs of reduction in the pace of reforms, and up to this point we're still awaiting, for instance, the formats for disclosing interests and taxes in Mexico. No? 4 years after reform, we're still waiting for the formats, no? Which is, it's a very good trick, and it's a procedural issue, but it's still open. The other thing that happened is that the Mexican political class, regardless of the political party they represent, understood that, let me use this very silly example of lucha libre, no? That when you are a politician and you are in the political arena, you are basically in something like a ring for lucha libre. No? You may be very technocratic or a very tough guy, no? A rudo, as we call it in Mexican lucha libre, but they are part of the same ring, no? And they understand the rules of the game. And so they can, hit someone with a chair, but they understand where they are hitting this person or this fighter, so they understand the political circus very well. But when civil society and journalists and the economic sector go into the ring, it's very complicated to do exactly the same that you were doing before. So there is a common understanding right now in Mexican political class that it's easier to provide a good show of lucha libre when you don't have independent observers and commentators next to you in the ring, when you don't have open parliaments, where you have to discuss technically, basing all your comments on evidence and discussing very, very sophisticated and boring items with a lot of people. It's easier if they are just the public. So in many of the formal and informal conversations we had with the candidates, the 3 leading candidates in Mexico, it was very clear that they didn't like the economic councils and civil society above the ring, but as very, very good and decent observers of reality, no? Clapping when it was necessary or booing what was the occasion, but not in the same ring that the political class. That's the bad part of the story. Now let me move to the ugly in the final minutes. The ugly is becoming the ugliest part of the story, which is the political redefinition of what corruption is and corruption is not. And this may seem more an issue for Roland Barthes or the French philosophers, the postmodern discussions, but it's not. When we are talking about the imperio de la ley, the preeminence of the law above everyone, well, the law may be interpreted by the courts, but it's not politically interpreted by anyone. You simply you are law-abiding, and you may challenge the law, and you go to court, and you use amparos and other tools, but you don't have an hermeneutic interpretation of what is moral, what is legal, what is right and wrong. And I think President López Obrador has been extremely successful in these 120 days to redefine publicly what corruption is and is not. If he's doing direct awarding of contracts, which is obviously a legal possibility, because they are conducting the direct awarding, they are publicly claiming that it's honest. No? You don't have to witness it. We don't have to disclose the information. You have to trust us, no? Because we're decent people. So this is not crooked. This is not a corrupt behavior. 6 months ago, direct awarding during the campaign was equal to corruption, no? And now it's been redefined. No? If I'm not disclosing the documents in which I'm basing my decisions, well, you have to trust me because I'm an honest guy. No? There's nothing like trust but verify, no? Using the Reagan analogy, no? For negotiating peace with Gorbachev. No? There's nothing like, no, you have to trust me. I'm an honest guy, and I'm pretty sure he's an honest guy. No? I'm not going to say he's a crooked politician. I'm pretty sure he's an honest guy. But government is not about, trusting everyone all the time, and it's not a solo game with only one person. No? There are interests, currents of thinking. There are many, many ways of dealing with the situation. So the main problem right now is that we all agree that corruption and impunity are terrible things in Mexico. We want them to go away. But the definition of what is corruption goes very much away from the law itself. It's becoming a moral problem. It's becoming a public speech issue. It's becoming very symbolic, but it's naturally, and maybe we can have a certain agreement on this, is very sadly away from the law itself. We're moving backwards in terms of understanding that it's not the supremacy of the law, but the interpretation, the political interpretation of the law, what is relevant for general public opinion. So we're in favor of the same goals, but we are not really using the same tools for understanding this new situation. We finally accepted that corruption is not endemic in Mexico, but epidemic in Mexico, which is different. I also disagree with President Peña on the cultural understanding of corruption. It's epidemic, but not endemic. It's not a Mexican problem. It's a problem that has an epidemic behavior in Mexico, but the means to solve that end and to control that situation are very much associated now with the symbolic approach and the political speech rather than the procedures, organization, and tools that the law provide. Thank you.
Thank you, Eduardo. And finally, we have David, please.
Thank you so much. I want to thank the Mexico Center of Rice University Baker Institute for Public Policy for this invitation, and especially Tony Payan and Rodrigo Montes de Oca for considering me in this panel. It is an honor to share this table with my colleagues, and it has been a pleasure to hear Justice Medina Mora. I want to approach the role of the Mexican Supreme Court and its doctrine about the proper place for the Army in homeland security in the backdrop of a liberal democracy. All this, of course, from the point of view of judicial review. I divide my participation in the following points. First, a brief introduction. Second, the standards of judicial review on the subject matter. Third, the scope of judicial review. This is where it can reach. Finally, I want to suggest some important questions to be solved by the Supreme Court in the years to come. So I want to organize some precedents that I think are important for this discussion. First, an introduction. In Mexico, we praise to have a written constitution from 1917 in which we estrange human rights, separation of powers, and a federal model according to which the federal government only has enumerated powers, being the rest reserved to the states or to the people. We think our constitution embodies the idea of a liberal democracy, so when we expound the constitution, we try to take this into account. We can say that from the beginning of the Constitution, we had judicial review. Still, for most part of that last century, it didn't reach the whole Constitution. We are proud for designing amparo, which is a cause of action for individual plaintiff to call into question legislation for violating human rights before federal judges. Still, this power to set aside legislation repugnant to the Constitution did not reach problems of separation of powers, federalism, and democracy for most of last century, because amparo was useless, or simply because those issues were considered by the Supreme Court political questions. All this changed from 1994 on. We had constitutional amendments that have turned the Constitution justiciable in all its parts. The Supreme Court was designed or redesigned to have powers similar to those vested on constitutional courts in Europe. And from there on, the Mexican Supreme Court has been established, I think, as a real check on the political branches, because it can review their decisions under the principles now of human rights, separation of powers, federalism, and democracy. Just in 2011, amparo was reformed in the Constitution to be a cause of action to protect human rights in a much broader sense than before. It is for these lines of incremental improvement in our judicial review system that recently we have turned the decision of political branches, being the executive alone or together with Congress by legislation, to deploy army forces and troops for homeland security purposes from non-justiciable to perfectly justiciable questions to be resolved by the Supreme Court, and I think by every judge, being this federal or local. It is now a problem of law, not only of policy. The proof of this is not only a group of precedents where the court has actually struck down legislation permitting the use of army by the executive, but also for a recent precedent where the court said citizens have a standing to question a statute when it has not been applied to them if public security powers are granted to the army, for the risk is created for human rights, notwithstanding the case and controversy clause in the Constitution, pretty similar to the one that is in the American Constitution, that only permits federal judges to decide on the merit of the cases when there is an actual harm, nor hypothetical. So the court allowed for a particular plaintiff to come to question the law, even though it wasn't applied to them. There is another important precedent in this sense, where the court ruled that being through Congress excluded commands coming from military authority from injunctions in amparo. This is judicial order to stop the enforcement of a statute while pending in court. Even though the Congress banned this possibility, the court decided that this exclusion does not apply when judges might think there is an overstepping of its power. So I think with those precedents, the court says that the use of military force is totally justiciable before federal judges. Then, from the principle of judicial supremacy in constitutional interpretation, it is for the Supreme Court to decide if a decision of that sort, that of deploying military force in homeland security purposes, comport to Mexican values, or if it is contrary to our liberal democracy, which at the end is what we are expounding. This is how we get to the second point of this exposition, standards of judicial review. There are three precedents I want to discuss briefly. When army forces, rather than the police or civil institutions, are called to face threats of homeland security, constitutional debate is framed in the most abstract terms. Mark Tushnet, for instance, referring to the debate about national security and executive powers, has said the dispute is whether the Constitution protects rights in one way in peacetime, or if it protects them in another totally different way in time of crisis. If this is the case, the court will use different standards of review in each scenario. If not, the Constitution needs to be enforced evenly by the same standards of judicial review. Liberals tend to defend the former position. Jeremy Waldron argues it is a false dilemma when putting this problem as a trade-off between human rights and national security. In a liberal democracy, rights are not protected according to costs. Waldron argues the sacrifices of rights usually bears on insular minorities, and they don't produce a gross insecurity anyways, as my colleagues has made clear. Historically, in Mexico, in one extreme of the debate are those that deny any participation for army forces in homeland security, unless there is a declaration of Congress suspending rights, which is regulated in Article 29. In the other extreme of the debate are those that give leeway to the executive as commander-in-chief to use of the army when necessary. We can use, I think, this model to discuss precedent. My opinion is that the Supreme Court has sided in a middle point. The first important precedent is an old one, for us at least, is Acción de Inconstitucionalidad 1/1996. Sorry, this is the name we refer to in our Mexican precedent. It was decided in 1996, where the court said that Article 89 of the Constitution, which establishes executive power, bears a power in the executive to deploy army forces not only when necessary for national security, but also for what it called internal security, which includes threats within the country. So in this first precedent, the court clarified that it was not necessary a suspension of rights from the Congress. The executive could use it extraordinary in some cases. So in this precedent, the court interpreted that. But the court said that this power of the executive needs to be understood, and this is the important point, according to human rights. So the armed forces only could be used in extreme cases and always in help and subject to civil institutions. I think this is a very important precedent, sorry. And the other important case is a recent one. It's Acción de Inconstitucionalidad 6/2018, decided last year. Here, the court struck down the Internal Security Act, which was legislated by Congress, and in which is regulated the use of armed forces. In a way, I think Congress was legislating in the terms of the court in the first precedent, because the Congress said that it was producing a legislation to regulate that which the court said the executive can deploy in some circumstances. This, I think, is the leading case for us in our precedent, and the opinion finally was written down by Justice Medina Mora after a big discussions in the Supreme Court. The court reasoned Congress lacks power to legislate on the subject matter because it confused, and this is, I quote in the opinion, it confused internal security, which is part of the national security, with homeland security. In the opinion, the court says that homeland security is an exclusive power of civil institutions. This means police, and is vested in the federal government just as is in the states and municipalities. National security, on the opposite, which includes internal security, is a power of the executive which allows him to deploy the army, but it has to be understood never to collapse with homeland security. The act is unconstitutional, the court ruled, because it normalizes and makes permanent the use of army forces for homeland security purposes. The important part of this opinion, in my view, is that the court not only looked for the specific provisions in the Constitution, it reasoned, in my view, in legal principles, big principles, proper of liberal democracy. It reasoned that the legal design of Congress was repugnant to the idea of a limited government, federalism, and the proper role for civil institutions in our Constitution. It is important also that the court broke the different precedents of Inter-American Court of Human Rights, where the International Court insisted that army forces can only be deployed for homeland security purposes as a last resource, and in the most exceptional cases, and as long as it respects proportionality always. Because of this, the court added an obiter dicta, which I think is very important for the last amendment about National Guard. In this obiter dicta, the opinion says that being struck down, the Internal Security Act does not forecloses the executive from the deployment of army forces for internal security. But if that is the case, if the executive with no legislation deploys army forces for these purposes, it will be subject to constitutional limits. It needs to be extraordinary, this obiter dicta says, subject
and in complement of civil institutions regulated by rules and always accountable, which is the same language that is now in the last, in this constitutional amendment about National Guard. So it's going to be very interesting how this is going to be interpreted by the court when has a case before it. The third case is Acción de Inconstitucionalidad 25/2016. Here, the court did not interpret the executive power as a commander-in-chief as in the former cases. It struck down a state act that regulated the use of coercive power by local police. This is a precedent of homeland security from the standpoint of civil institutions. Nevertheless, I think it's very important also for the deployment of army forces. The important point is that the court said that when the use of coercive power is at hand by state actors, it is subject to the Constitution. It ruled that coercive powers is subject to the principles of legality, necessity, proportionality, and accountability. It also said it is subject to international human rights standards. The court made a statement that is, I think, important. Coercive power, it is not to be exercised with too much broad discretion. It is too risky for human rights to have the use of coercive powers with not a framework. When used, it is to be regulated, said the court says, in the sense to make possible for people to enjoy their rights, especially those needed to participate in democracy. My hypothesis is that this last precedent applies by analogy to the use of force made by any state body, either the police or the army force. So I think in the worst case scenario, the courts, in my view, has said that the use of coercive power has to be subject to these material principles. I pass now to the third point, which is the scope of judicial review. Judicial review is the power of judges to set aside legislation repugnant to the Constitution. In many countries, the natural reach of this power is the Constitution amendment itself. Once a rule of decision is entrenched in the Constitution, it is not to be called into question as justiciable. This was the case for Mexico for most of the time, and I think this is the case for many countries. So one question we could say is once the National Guard is now in the Constitution, there is not anything we can make about it, at least not in the judicial branch. I think there are some precedents of the Supreme Court that might question this conclusion. The important constitutional amendment of 2011 made the body of human rights international law binding as constitutional law. It was binding before. The important thing about this amendment is that it made it binding as constitutional law itself. In a first important case, Varios 912/2010, this is a case where the court acknowledged international treaties about human rights not only as binding, as I said, but as a constitutional role itself. Also said that the precedents coming from Inter-American Human Rights Court were binding for all judges in terms of a sort of stare decisis. And this is an important case because in here the court said that this ruling of the Inter-American Human Rights Court in which the case Rosendo Radilla it was binding for us. And this case said that it is contrary to the convention to have military judges to rule on criminal cases in where there is a civilian involved. So this is an important case, and the Supreme Court said that this precedent of the Inter-American Human Rights Court has to be binding. With this doctrine in mind, there was a second important case, which we call it in Mexico, Caso Yucatán. This is a case where the court set aside the provision of the Constitution itself because allowed administrative agencies to force people into community working for minor misdemeanors because without a judicial warrant. This was like a constitutional amendment in 2008 that allowed these agencies to force people into working and community working. And the court said that it doesn't matter that the Constitution has this provision, it has to be set aside because the covenants the treaties of human rights only permitted forced labor when there is a judicial warrant. So because of this, it was set aside. Nevertheless, after this precedent, the court decided contradicción de tesis 293, diagonal 2011. This is, I think, the leading case now, and it says that the Constitution shall be enforced against treaties of human rights, when there is an explicit restriction in the Constitution. So the court says, I'm not going to set aside anymore the Constitution when it goes against covenants in human rights, because now if I notice there is a restriction in the Constitution, this has to be enforced. From there on, the court has been exploring which provision of the Constitution amounts to a real restriction, but it remains open, the question whether there is a duty of the court to enforce covenant when a constitutional amendment not only restricts a human right, but this constitutional amendment takes out of the Constitution a human right itself. This is an open question. So finally, I get to my final point, which is what are the important questions for the court to resolve in the years to come? I pose first the interrogation whether there are conditions to make the question justiciable when the decision to deploy Army force for Homeland Security is written down directly in the Constitution. We have now this very recent constitutional amendment that permits the National Guard, and I think that most of us have more questions than answers how it's going to work. But one constitutional question also is the court to have the power to review this constitutional amendment in face of the human rights treaties or covenants? This is the first question. In my view, and this is a personal view, of course, the doctrine of constitutional restrictions, which I insist says that the court cannot set aside the Constitution when the purpose is to have a restriction written down in there, doesn't resolve the problem because a restriction always presupposes a human right below. And if you take the human right altogether, there is not a restriction, no? So I think that this is an important question. And I said not only depends on the evolving doctrine of constitutional restriction, but also the way the Constitution will be enforced as applied rather than on its face. The Constitution also is a rule of decisions to review legislation that will be produced according to this constitutional amendment. As I said, the precedent where the court struck down the Internal Security Act says as an obiter dicta that the executive can use the army only in exceptional cases with a language that is reflected now in the constitutional amendment. It's going to be a very important question how the court will interpret the constitutional language in order to control secondary legislation. At the end, and I finish by the statement I made at the beginning, the court has made clear it is a constitution is expounding which contain the ideal of a liberal democracy. Thank you.
Thank you. Well, I think we have about between 5 and 10 minutes for questions. I had a bunch of questions, but I'm going to skip that because then it'll go long. I'd rather give you the microphone. I'm having lunch with them, and so I can ask all the questions I want. But you only have about 10 minutes, so please. Any questions? Yes. Over here in the middle. Thank you.
I was impressed with your statement that a large percentage of people are simply not paying taxes at all. And that raises a question in my mind, is it because there are no laws that impose a tax base? Or secondly, have laws been enacted by proper legislative authority and those laws are simply not being enforced, in which case the problem is at the administrative level? It seems to me, whichever way you go on that, there is a question of legitimacy. We don't talk much about legitimacy in our modern world because we've seen we're going beyond that, but legitimacy is basic to everything. The right to exercise power, that's the issue that was raised over here. Police power, has to be cloaked with legitimacy. Now, the problem we face in legitimacy is it's not an ex post facto, it's not a post fact thing where someone does something, you say, well, you use too much force. That's after the fact. The question is, did they have the right to use force in the first place? It seems to me that there are three possible answers to this question. One, you've got traditional authority. In other words, they have the authority because it's always been there. Secondly, you have charismatic authority. That is, someone like Hugo Chavez just suddenly announces that I know the right way and I'm going to declare the right way and I've got special inspiration and we're going to exercise the right of power. Didn't we see it in Maduro? So you have charismatic authority going against traditional authority. But in Mexico, it seems to me that there's a foundation that could be built upon, and that is the third level of legitimacy, which is legal rational. To have a rational basis for the enactment of laws which are uniformly enforced. So my question is, at this point in time, is there a way to build a system that is built upon a legal, rational, statutory foundation for the lawful exercise of deadly force?
Thank you. Eduardo, you want to take that? And anybody, but we'll start with Eduardo if you want to answer that.
I think there is a way for doing that, and that's the reason why civil society, business community, and public opinion are fighting for institutional reform and changing policies and another issue. And I think this panel is a very good example of the current discussion in Mexico, which is a combination of political, legal, technical, and I think there is a way for that. Let me make a brief comment on something that always disturbs me because of we can get lost in translation. There is a temptation to say that accountability, the concept that in English is very frequent, has no translation to Spanish, and especially to Mexico. I don't know if you've heard that, Tony, but it was very commonly said in the 80s and 90s. And as far as I understand, and there are very good scholars and legal experts here, el régimen de responsabilidades, in fact, is the best possible translation to accountability. No? Civil responsibility, political responsibility, administrative responsibility, criminal responsibility. But we have spent so much time saying, following not only President Peña Nieto, but many other people saying that all of these are cultural problems, that we haven't reflected on a very simple fact. Since the 19th century, we have been discussing our régimen de responsabilidades, and it's a perfect translation that is not commonly used and exercised in practical terms. So I will say that there is a path. The path is not new. The path comes from our constitutional origins and legal discussions, but we haven't appropriated the concept in very practical terms. When you have a major corruption scandal in the country, we never review political responsibility, criminal responsibility, administrative responsibility. We don't review it in that way, and it normally leads to other forms of authority and legitimacy. But I do think there is a path, and I do think around the table are very good examples that we are following the path you are suggesting for having a valid legal system as the foundation of every single political and practical decision in the country.
Catalina, but to follow on that, one of the big issues is that the path that you're speaking about depends also on checks and balances and political equilibrium. And when Morena has almost 2/3 in each of the chambers of Congress, and they're redefining the discourse on what corruption is, right? They were very quick to point out the speck in the other's eye, and they got, big one in their own eye, but it goes through political accountability. So with such overwhelming political imbalance, is that path narrower now, Catalina?
So I guess it is narrower. I would just say on the point of legitimacy, it's a very interesting issue. And one of the reasons to say that militarizing public security, not only to combat organized crime, but to do everyday issues like domestic violence, extortion, anything that comes under the umbrella of public security, is the argument that the police, people don't trust police, and therefore they don't have legitimacy, while everybody likes the military and everybody trusts the military, so therefore it's a legitimate institution, and therefore, and this is the part where it's not evidence-based, it's a legitimate policy to give public security to the armed forces. And so I think we have confused the argument in several different dimensions. One of them is because the military is a trusted and legitimate institution in the eyes of the public, then therefore it's a legitimate decision to militarize public security. And the other is because Morena has the majority of Congress, then any decision that Morena has and any decision that López Obrador can come up with will also be a legitimate decision. And I think there's a problem there in terms of where we're at. And I'll just say one final thing in terms of accountability. I think what David was saying is very interesting of what the court has said in terms of accountability of federal forces, especially the armed forces, that they have to be subjected to civil institutions and accountability in general. The National Institute for Access of Information has decided in 3 different resolutions in the past weeks that the Army is obliged to give information regarding what goes on in what they're doing in the country, in terms of things so basic as have they detained police, local police officers? Have they killed police officers in engagement? How many civilians have they killed? Because since 2014, the Ministry of Defense has denied this information through acts of information request, and they don't make this information public. So today is the first date when they're supposed to answer what the National Institute of Access of Information has said that they have to do, which is make public all of this information. And so it's very important in the context of the Guardia Nacional is being created with the military and the armed forces doing public security as if they were a civil institution. And the question now is, will they really be subjected to civil other responsibilities as other civil institutions are when they are conducting public security tasks? And so we'll see further today if they actually make this information public or they go the other way and decide to keep it all under the dark, in the dark.
Carlos, I have another a quick question before I go to Alfonso, because I think it's important. Populism is the same everywhere. We have a right populist leader in the United States. There is a left-wing populist leader in Mexico. And one of the characteristics of populism, whatever the brand may be, is that they tend to dominate the public discourse. And they define what is corruption, what can be disclosed, what is the way, and they assume a certain degree of legitimacy by creating a certain, and whereas our own president in the United States, Mr. Trump, does it by Twitter and communicating with 60 million people directly, Mr. López Obrador sets the agenda for the media and the public discourse every morning from 7 a.m. to 9 a.m. And even because I follow you on Twitter and because I think you're very active in responding to a lot, but even then you're responding to what he says. So how to wrest away the public discourse and the agenda, the day-to-day agenda from people, for us, Trump, for us, López Obrador. How do you stop responding to him and then really begin to do the business that it's supposed to be done? I'll leave that on the table, and then let's get to Alfonso, Pam, and then you can pick up that. Alfonso.
Thank you. No, it's a comment and And also a question, thank you. It's a comment and a question on as a comparatist, when I approach the legislation in Mexico, I see that the Congress in Mexico works very well. The rule of law in Mexico, the corruption is not a problem of law. And sometimes you even read it and you see how enormous effort has been done in the structure. Of course, in every country, the quality of the law at some points can be improved, the way we write, the way we understand what we want to say. But technically, Mexico, and this is the big paradox of the corruption in Mexico, has a very solid ordenamiento jurídico. It's a very solid structure. So sometimes this is when we approach the question of the Estado de Derecho, which is for me the definition that I prefer, although I agree it's more complex than the imperio de la ley. Imperio de la ley would be more like a notion inside the Estado de Derecho, technically. It's that we need to put the institutions to work. We need to enforce the law, because the law is there already. And this is why I don't envision, although it has been said, a very large like loss of control of the country. No, the institutions are there. What we need is really to give the intention of applying and reinforcing the Estado de Derecho. So this was more my statement about what I see in the legislation, and again, as a comparatist, when I approach the different texts that deal with corruption or with law enforcement and security. And the second one goes a bit beyond, it's not related to that. Has at some point been talked about a possible private security versus public security? We know that the coercion of the law enforcement and coercion is on the hands of the state. So in our civil law countries, it's complex to talk about private security, giving enforcement to private people to really enforce the law. Has it been talked at some point in the discussion, the possibility of creating private securities versus public security offices? Thank you.
You want to start, Carlos, and then whoever else wants to take that?
Sure. Well, that's the $64 million question. How to address a political year with such masterful skill to dominate the public conversation. I would think that, the question is not how to avoid it, because this is the president. He has a very ambitious, very aggressive communication policy. And, by definition, what the president says is news. So I think that from the standpoint of a journalistic enterprise, you cannot avoid it. And actually avoiding it would be wrong. But the thing is, you can decide how to engage it. Or, to use Catalina's term, the press can define its own rules of engagement regarding, the president's communication policy. And I think that from the standpoint of Mexico, in contrast with what has happened in the US, where, the media has developed, I think, these rules of engagement and has actually, done a very significant job in, for instance, fact-checking the president, which is something that has not happened in Mexico, or at least not yet. I think that the bottom line of this problem is the fact that most of the Mexican media is used to developing this sort of tacit understanding with power, where, given the fact that a lot of Mexican media is dependent upon official publicity, it's not as if they sit down and, define how they're going to engage. This is a game of signals. And I think a lot of the Mexican media is acting, in the logic of business as usual. Regarding their relationship with the president, apart from very few outlets that have openly taken a stand of being critical, of being independent, of actually having their own agenda, their own coverage project, so to speak, most of the media is behaving as they used to behave, which is, we like to talk about the media as a watchdog, right? But in this case, most of the Mexican media is not assuming the role of the watchdog, but more the role of of the dog that runs to whatever side power throws the ball to. And this makes this communication policy of López Obrador very successful because he's always on top of things. It makes it very difficult for journalists to develop their own agenda. And when you combine that with the fact that, you know, a lot of the owners of the media are willing to play up with this, then what you have is journalism, as I defined it in my remarks, is being pushed to the margins. The best journalism that you can find today in Mexico, you know, except for a few cases, you're not going to find it in the mainstream media. You're going to find it in marginal media or online web pages, where, you know, it's still, that means it's financially very vulnerable. But if you look for actual, investigative journalism in the mainstream media, you will find some, granted, but very little. And of course, very far away from what we actually need. For instance, regarding what Eduardo was just saying, asignaciones directas, how do you call that in English?
Direct awarding.
Direct awarding is such
of
an
public
issue
contracts, yeah. Public
that very few media outlets are looking into. Actually, what was published recently in Reforma was as an investigation that was not done by Reforma reporters. It was done by reporters working in a civil society organization called Mexicanos contra la Corrupción. So, I mean, this is, a very eloquent example of journalism being pushed to the sides. Some of the best journalism that is being done in Mexico today is not being done within the media system. Mm-hmm. It's being done in civil society, in alternative media, in academia. So I think that speaks volumes to the difficulty of providing this counter-narrative you were talking about.
David, let me pick up on the question that Alfonso put on the table about the distinction between legislating and implementing. And I think it's an important one in Mexico because Mexico is not a country that lacks institutions, right? There are plenty of institutions. There's a Congress. In fact, I often explain to my own students that much of the Mexican Constitution, the basic wiring, internal wiring of the Mexican Constitution is essentially the American Constitution. You can highlight the entire American Constitution inside the Mexican Constitution. It's much bigger, but it's certainly a lot of these principles and concepts were imported from American and French thought, right? So there's clearly the issue of institutions. So what's failing in terms of implementation? And then let me add one important thing: how to protect these institutions that have been built and maybe rickety and difficult, but still there, from the attack that the president has conducted on institutions. By the way, our own president is very fond of attacking institutions, but American institutions are seen as resilient and strong, and they'll probably outlive the current wave of American populism. Will Mexican institutions, which are a lot more delicate, nascent, and perhaps more vulnerable, withstand the attacks? And what is at the end of this tunnel?
Thank you. Yes, it's a very important question, I think, and I start by the last question. And I think that the one of the things that this new administration has put on the spotlight is how strong the institutions were when they reached in this administration. And I think that judicial power, for instance, the federal judicial powers, has been one of the guarantees that it's being set for human rights, for separation of power, federalism. Of course, the judges are not accountable to the people. They are not elected by democracy. So this is good news, at least for check and balance, because just as the president and the Congress belong to the same party, at least most of them, and there is not a strong opposition, people resort to judges to defend their rights. But this is something that I relate to, which I said in my exposition. The Constitution now is a whole justiciable for good reasons. It not used to be like this before because many of the provisions of the constitutions were political questions according to the doctrine of the Supreme Court. So, and I think this changed just some years before this new administration. So I think now we have a very strong power to resort to judges to question or to put into question the decision of government, not only of the executive, but also of Congress. And I will add another important task that was being discussed before. It is not only that I think federal judges are trying to check on political branches, but also I think that the judges have established the duty to protect human rights in a way not only to avoid interference from government, but also to make better conditions for these rights to be exercised. And I put an example that Carlos was talking about, this how these direct awardings to the media, when there is not, when there are not rules to be applied, Supreme Court has struck down as unconstitutional the passiveness of the Congress not to legislate. In a recent, very famous case 2 years ago, the Supreme Court said explicitly, it is the duty to Congress to legislate on this ground because it affects freedom of speech. And this is very important because the court, I think, is not only the watchdog for avoiding attacks, but also the Supreme Court has, I think, a sort of a duty to make conditions better for the exercise of rights. Of course, the court is not going to intervene in policy issues. There is not to the Supreme Court to decide whether a policy is better one than another. It is not the role for the court to decide this. But of course, it's a decision for the court to make which are the conditions that are better for a liberal democracy. And I think that this court has made it. Of course, we have a federal system, and because of this, we have different levels of government. So there is the federal judicial branch, but also there are the state judicial branches. And we have a country in which there are different qualities in judicial branches, and not all of them are probably the best. So I think that we have to work in the local level, so we can have judges that have also this responsibility, as I think it is now compliant in the federal level.
That is an interesting concept because obviously in the U.S. the Supreme Court has reaffirmed several times that Congress cannot legislate by not acting. It has to be explicit, has to be said. Congress cannot, so it's a kind of an important principle. Last question from me to Bojorquez, if nobody else has any questions. You led the National Anti-Corruption System effort, and you pushed, and I think President Peña was quite vulnerable individually, personally, because he was engaged in acts of corruption. And so he had to kind of placate civil society and allow legislation to come through. And you also had a Congress that was much more evenly divided politically upon the PRD and the PRI and other political parties. And so the opportunity to get in Congress, in the halls of Congress, and push legislation anti-corruption, and to have the sensitivity in Congress to do this, and build different coalitions to do this, and of course the president not interfering as much, and you talked about some resistance and so on, but the conditions, politically speaking, were there. That's not the case now. Do you think that the fundamental conditions to keep pushing for action from Congress, when you have such a solid political color in the halls of Congress and the executive are there, how is that making your job to push for the right policies and the right legislation more or less difficult?
Well, it's not the 64,000 pesos question. It is exactly what is going to define civil society in the next 10 years. What you're asking is exactly what is going to be the definition. Let me make a quick recount. Is civil society being plural, diverse, complex, opposition to a government? It is not. No? Our role is not to take power and replace those in government with our ideas. We are a catalyst. No? We are a very complex and sophisticated group of interests and mandates that is catalyzing change. Are we checks and balances of power? No? In the way you are presenting the media, for instance, no? As a watchdog? Well, of course, we played that role, but it's not the main purpose of civil society. By simply having a conversation like this one, which is a critical conversation on policies and constitutional matters, well, you're actually created the sense of a checks and balance scheme, but it is not. No? This is an intellectual, very sophisticated battle, and you are basically addressing public opinion, policymakers, legislators with the best possible options for making decisions. Now, it doesn't mean that you cannot organize yourself in creative ways for addressing the current political composition of the government. I have one single example. I have a lot of doubts about the final product of the design of the new Attorney General's office. No? We were doing that through 16 round tables with the elected government and the elected Congress. And it was, I'm pretty sure that Catalina knows a lot about these discussions because you were part of a broader coalition that was connected to these issues. But, you know, it wasn't exactly the way I will prefer to do institutional design. No? I think it's very difficult to do institutional design in that way. But these 16 roundtables produced a piece of legislation that it's going to be challenging in many ways, but that actually reflects a lot of the discussions outside the government and not only the governmental or the new administration perspective. It's going to challenge us in many, many ways, Tony, because we have to be more creative, more effective. It's not only a battle that is going to be conducted in public opinion and Twitter. No, you need to sit with legislators to create stuff. I mean, it's not you cannot simply send them a letter or tweet them. You need to take advantage of every single possible public hearing, and at the same time, we also have to be more intelligent in terms of agenda setting. Because if we don't want to play the role you were mentioning before, you know, reacting to the government, waiting for them to make the first move, we have the moral obligation of bringing new standards to the country, moving the public agenda, setting a different agenda, and it's going to be very, very interesting for us to hopefully change, reform our tactics, or even evolve if we are lucky enough. I foresee a complex scenario for those that were very comfortable simply sending WhatsApps to ministers and friends. No, you know, WhatsApp politics are very interesting if you have access.
All right.
But it's going to be challenging for those that were very close to power, right, to understand their new role as catalysts, as watchdogs, but not as opposition or as a formal check and balance to the power of a political group right now.
Thank you, Eduardo. Let me invite Tom for 30 seconds to close our event and thank everyone and close this important event. He's our partner. You can see it up there, the International Law section of the State Bar of Texas, and so it's important. Tom, thank you very much.
Thank you. I really appreciate everyone. Appreciate the participation of the Baker Institute and the Mexico Center in particular, and all the help that Tony's given us. I think this was a great panel. It really is a nice end to a lot of study that we have been doing within the section with regard to Mexico, although we have one more big step, of course. I hope I see many of you next week at this time in Mexico City, and where we will continue to explore many of these issues and continue to discuss. So thank you so much, everyone. I hope you have the rest of a good afternoon and a good weekend, and hope to see you next week in Mexico City.
And thank you to our panel. Have a good day.